Good afternoon. I'm Bill Morrison. I'm a partner in Withum's Forensic Evaluation Group. I would be remiss if we didn't start by remembering those who have passed from this virus, including our own beloved Judge John Conte. We offer our condolences to the entire Conte and Tafuri family, and we wish them our best in this time. We've assembled a team to address the economic issues you're all facing from COVID-19. We have 3 accountants from Withum and 3 attorneys from Pashman Stein who have been working on these articles and producing articles which are now on our websites. We also have Richard Weiner and Joseph Maurice with us. The business issues and taxes will be addressed by Ken DeGraw, who is a forensic accountant and tax specialist at Withum. Fraud issues will be addressed by Jessica Holaba from Withum. The government programs are going to be addressed by Frank Huddle and Tom Reck. Tom's a very experienced forensic accountant. Frank Huddle brings the perspective of a law partner, a tax expert, and a banker, and one who has served in government. Tom and Frank have immersed themselves in these laws over the past several weeks. Insurance issues and force majeure will be addressed by Dennis Smith of Pashman Stein. He's extremely experienced in these areas. Jessica Holaba, who testifies frequently on issues of business interruption, will address this from an accounting perspective. James Boyan will discuss employment issues. What makes this panel unique is we have the insights of Richard Weiner, past bar president of Bergen County, and the current president, Joseph Maurice. Both of these gentlemen have been intimately involved in all the economic issues that you're now facing. They've been in constant Zoom and video meetings and conducting telephone calls with public officials and members of the bar. I'm now going to introduce our host, Joseph Maurice. Joe is a partner at Cohn Lifflin. He is certified by the Supreme Court of New Jersey as a civil attorney, and he is the current president of the Bergen County Bar Association. Joe?
Thank you very much, Bill. I first want to reach out and thank the Bergen County Bar Association for working with Bill to help put this seminar together. I know from dealing with and hearing from many of our members that the issues that we're going to discuss today are very important, and there are certain questions that we already are aware of. We've asked for questions. You can use the chat platform that we have on here to send them to me, and I will help filter them in. But we've received some in advance. The flyer had some information on it to submit those, and we've already seen those questions, and most hopefully will be answered by the panelists as we're going through the program. But if we miss anything, we'll handle that toward the end after the panelist completes their presentation and the slideshow. I want to thank Frank O'Mara as well. He is invaluable. On March 18th, I was sworn in as president, and the next day, he and I set up open communications with our assignment judge, Bonnie Misdahl, who has been wonderful, the sheriff, as well as our county executive, so that we and our members could have the most updated information. So I thank you to all of them, and I thank Frank O'Mara and the rest of the staff at the Bar Association for helping set that up for our members. As a matter of housekeeping, the Bar Association is going to provide 2 credits for no fee for any attorneys who follow this program or attend this program. I'll give a code out somewhere in the middle that you can put on your form, which is located on the handout section on the right-hand side. It should be on the right-hand side of your screen. It says virtual courtroom seminar. I apologize for it probably being mismarked. That is the CLE form that you can download, print out, and fill in and send in. Let me be clear, it's Bergen County Bar is doing this for all attorneys who attend this. We did it to just the Bergen County Bar members. So I hope everyone appreciates that. We are trying to provide the service to you. And with that, again, the appreciation goes to our panelists. Bill introduced them. He didn't get to introduce himself. He's a partner at Withum, Smith & Brown. He's a former FBI agent. He spent over 40 years doing forensic work. So he was an invaluable leader in putting this together. Rich Weiner, you heard as a prior bar president. We appreciate his participation here. He's been working tirelessly as well. He's a family law practitioner doing arbitrations and matrimonial work at Aronson, Weiner, Salerno, and Kaufman. We have also Ken DeGraw, who's a member of Withum's Forensic Evaluation Services, focusing on bankruptcy and troubled businesses. We have Frank Huddle, a partner at Pashman Stein, concentrating his practice in transactional work, specializing in taxation, estate planning, mergers and acquisitions, and corporate law. We have Tom Reck. Tom is also a partner at Withum and a member of the Forensic Evaluation Services. He has over 20 years experience in an array of industries. Jessica Hollenbaugh is a partner at Withum's Forensic Evaluation Services Department. She provides a wide range of forensic accounting services in connection with both civil and criminal litigation. She's a certified fraud examiner. We have Dennis Smith. Dennis is the founding partner of Pashman Stein, and he's chair of the firm's insurance coverage practice. And James Boylan, he's a partner at Pashman Stein as well, in Hackensack, primary area of practice employment law. So I thank all the participants in putting this together and spending their time before, and there was a lot of time put in before the seminar and during the seminar, and the service that they are providing to the Bergen County Bar Association. So thank you, everyone. With that, I will turn the first presentation over to my friend, Richard Weiner.
Thanks, Joe. Appreciate it. And I appreciate your hard work too, coming on, president of the bar, without the beefsteak and your introduction. So this is really your formal introduction to 250 people. I know our bar association's appreciative, and hopefully we make the beefsteak and your inauguration up to you one of these days. So thank you for your hard work and and your lack of formality in getting into the chairs and being president. I've been fortunate enough to be at the forefront of this. I've been part of about 30 to 35 law firms, single practitioners and law firms that we started about 3 weeks ago on weekly calls, managing partners and others who have participated just to get ideas back and forth to help each other out. I'm taking my presentation different twist, more of a business-oriented twist for bar members and what's gone on, and some head notes for everyone to know. So one thing I have learned and will share is, and these gentlemen are going to talk more about it today, we're constantly evolving. These regulations with forgivable loans and what's gone on with the different managing of law firms is forever evolving. I've gotten calls and emails as late as 11 and 12 o'clock at night that, you know, applications are changing on this program. And as I said, Frank's going to get into it more and more, but we're all getting a lot of mixed messages. And when we sit on this call, and I will welcome people if they want to be part of our weekly call, actually either call me or go on my website and just get my email and I'll add you to the call. And what we have learned is so many mixed messages about should we be submitting, you know, 1 application, 2 applications, 5 applications. We know we can only accept 1. You can apply to many others. And in fact, part of the mixed messages, the Trial Lawyers Association, the president sent out an email yesterday that I circulated, who basically gave advice and says, I'm giving you guys advice to go to 3-4 different banks, make your applications, outline some concerns. And just today on our call earlier, you know, that's being discouraged. And once again, Frank is going to talk about that more. If you have a relationship, you know, from a business standpoint with a particular bank, that's the one you should be honing in on. And in fact, today on our call, one of the attorneys, Angelo Sarno, was talking about his bank particularly asked for a certification that that his firm didn't apply to any other banks, et cetera. So you need to be wary of putting, I think, a lot of faith in not what you're reading, but what your bankers are saying or what your personal contacts are saying. You know, the other message that came out to us a couple of days ago was that a lot of banks, especially the local banks, are dropping out because the feds initially told these banks that they would be reimbursed for any money that they would pay out to us. They'd be reimbursed within a 15-day period. And now they're being told it could be potentially, you know, a 9-week period, even longer than that, so that some banks were discouraged. That turned into be, you know, false publicity as well. So just be wary of all these different comments that you're reading. We're hoping, if your application is not in, and most of the firms we're talking to, their applications are not, or are in fact in. And if they're not, that you listen to the gentlemen that are going to talk today, as Jessica as well, on the insurance aspect as to what you can and cannot do. From a business standpoint, I will tell you that we have heard all across the board, Joe and I, as to what different firms are doing by way of furloughing, by way of laying people off, by way of unemployment. And I will tell you on this call, if you lined up 30, 35 firms, there's a lot of different opinions as to what's going on. And my message is, you got to do what's right for your particular firm. There is no uniformity. Some firms we're hearing are going 10% across the board. Other firms, 25% reductions. Tom and Frank are going to tell you today what you can and cannot do by way of reductions. I'm not going to get into those technical aspects, but it's important that you listen very carefully to that portion of the conversation. Many people have called me and have been part of our call, say, what do you recommend? You recommend 10%, you recommend 20%. And once again, everyone is different. A personal injury firm that is on our call recently had a significant personal injury lawsuit recovery, so they're able to fund payroll for an extended period of time. They happen to be lucky in comparison to a company that may do transactional work, that may be slow right now, like a lot of other people, that we're witnessing. So what's my message? There is across the board different comments on what to do and not to do, but make sure Tom and Frank give you great guidance, what you're going to do in terms of how you can drop people, when you can put people back on, the difference between furloughing and allowing you to continue benefits on a furlough in comparison to an unemployment, et cetera. Another housekeeping thing that has nothing to do with the forgivable loans, but has to do with law firm management, relates to issues that have come up with Zoom and our mediations and meetings. There has been major concerns brought to the Bar Association leaders on a statewide basis that there's been some privacy issues. Someone brought to our attention that the CEO in Zoom was on either CNBC or one of the other large shows the other night. Very disappointed in his privacy and the lack of what's going on in Zoom. Some of the mediators statewide are doing these conference room and they're going back and forth into the two different conference rooms with an attorney and a client and another attorney in a separate conference room, and they're able to jockey back and forth. There is a concern on the privacy aspect of that. State Bar is talking to Justice Ravner and Judge Grant with respect to that. And I think the message that I want to get out, and that we've talked to Judge Misdall and others about, especially some retired judges and lawyers that do mediation, clients shouldn't be compelled to enter into a mediation on Zoom if they don't feel comfortable. And in the family law field, I've noticed that there are certain people who are concerned that their other spouse are residing with a girlfriend who may have children. They may be in a 2-bedroom apartment in New York, reticent to want to conduct mediation. And I think we all need to be cognizant of that. And we need to tell the judges and or the mediator that your client is not comfortable with that and not feel any resentment or pushback. And that's one of the things that we spoke about today. Cheryl Seiden, who's head of the executive committee of the Family Part and State Bar, saying that is a concern that we don't get pushback, because in the civil arena and in the matrimonial arena, we're often told by a judge, hey, make sure you get 2 mediations in within the next 45 days or 3 mediations in within 60 days. And I think we need to stand up on case management conference that we've been regularly attending and say to a judge, this may not be the case where you're going to be able to fulfill that. And I think if there's any concern, Joe should know, and the leaders of the Bar Association, Frank O'Mara, should know that there is some pushback. The other thing that we were told today by State Bar has to do with, evidently some counties are streaming motions and streaming hearings, so that today we learned there's a major concern on privacy, and that your neighbor could be listening to a motion being streamed out of Union County, may or may not involve children, may or may not involve sensitive issues from a civil, personal injury, matrimonial side. So we're told that although it's an open courtroom, you can ask a judge, if a motion is being streamed, to turn off the streaming component of their apparatus that they have in the courtroom, by saying that there may be a sensitive issue that you don't want to share with others. But there has been concerns brought to the state bar about motion hearings. And I realize we've all gotten notices about motions going on. And there's a whole motion calendar for April 24th that my firm has gotten notice of. So that's a concern that I wanted people to make sure they're aware of and ask about the turning off of that concept. A couple of housekeeping things towards the end. State Bar Association has in fact canceled the Atlantic City large meeting where we get 2,500 participants. They have canceled that in its totality. A question was asked today, is it going to be pushed back? And the answer is no. Our Atlantic City meeting has been canceled. If any of you have put deposits on hotels or registration, you're going to get that back. The State Bar is running from April, I think, either April 13th or May 13th to May 15th, I believe, seminars where you can get credits and go that route. But clearly there's not going to be the same formality, and they're not rescheduling the State Bar Convention. The Family Law Convention that was scheduled for Nashville and pushed back several times has also been canceled. And I was asked to advise people that the State Bar trip coming up for Napa, which is in October, no decision has been made with regard to that trip. The other thing I want to add is, besides, like I said, thanking people on this call, and surely, as Joe indicated, from the bar perspective, Withum Smith, Bill and Tom Reck, Bill Morrison and Tom Reck have stepped up. They've been part of our calls that we've been on. They've been working tirelessly. So along with this panel, from the quality law firm of Pashman Stein, Bill and Tom deserve a lot of credit. And I'm hoping that, we'll remember this when we go forward, with having to retain forensic accountant or accounting firms. But they've gone beyond the call of duty, late night with me and Joe and other people in our committee going through things. Joe and I were also part of a call that Josh Gottheimer, and this is not a political announcement, this is just what I want to bring to everyone's attention, how we're all working together. Josh Gottheimer got the leaders of the bars from Bergen, Passaic, Warren, and Sussex on the phone the other night. He, with his staff, discussed these forgivable loans, said that money is going to be available to people, whether they applied early or late, talked to us about the potential second round of funding. So nobody's ignoring us. People are available to Joe. He has shown his availability, and I think that's an important part, that people are working together and open to suggestions. So from an administrative standpoint, go ahead.
Rich, I just want to add, because you did bring that up, that Josh Gottheimer has been incredibly available to the Bar Association, and I don't, that has to be said, along with the fact that Senator Kristen Corrado has also been very astute, and she's listened to the Bar Association issues and has gone back and forth with us on some. And we are working on a virtual notary, hopefully to get a virtual notary law passed or an executive order.
Okay, great. No, I appreciate that. And the fact that we're getting that support as a bar association is very, very important. So that's it in closing. As I said, I wanted to hit some administrative issues. If people want to be part of the call going forward, I'd be more than happy to add people to the call, because we're going to continue. It's great to kick around ideas, but what the message that I'm giving people is, it is forever evolving. Tom Reck and I were on the phone an hour or two ago, and he's telling me about different changes and how things are evolving. But everyone's doing their best to try to give advice to our bar members. Don't hesitate to call one of us if people have questions or concerns. And once again, thank you. The people who work on this panel worked very hard to put together a quality presentation and work day and night. And I want to say thank you to both the people at Pashman and the people at Withum who have helped out a lot. Thanks.
Okay, I think we're going now to, was it Dennis? Ken DeGraw on business and tax issues is where I think we're going to begin. Is Ken on or is he muted?
I am on. Sorry about that.
That's okay.
Didn't realize I was first up. Fantastic.
There you are. Yeah, there's your video too. Okay, go ahead.
Welcome everyone. We'll start you out and try and put you to sleep here a little bit. So with the CARES Act that just came out, there were a number of tax law changes that came about as a result of that, that both you and within your businesses as well as your clients need to be aware of. Some of it has the ability to get some cash back in their pockets pretty quickly, which certainly everybody could use right now. One of the big ones is the use of net operating losses. The Tax Cut and Jobs Act from 2017 effectively did away with the ability to use net operating losses. Two things have happened, one of which is there was an 80% limitation going forward. That's been waived. So now you can offset 100% of your income with 100% of losses incurred in prior years. In addition, you're able to carry back losses up to 5 years that are incurred in 2018, 2019, or 2020. If you're a fiscal year filer, there's some nuances, but let's keep it simple. That's good news. It means you can go back to, there's two actually very good pieces of news in there, one of which is if you're a corporate taxpayer, you're currently paying taxes at 21%. By carrying it back 5 years in a time period when you were paying tax at 37%, it's pretty good tax arbitrage. Hopefully you can get a little bit more money in your pocket. One warning on that though, is that you're carrying it back to year 5 and year 4, both of which are closed tax years. So you're opening up the statute of limitations. So the kind of the heads up is just be careful of what you're carrying it back to. Make sure you're not taking an undue risk with any positions that may have been taken in those closed tax years. And certainly need to be aware of what's going on with the state tax component of that as well. To the extent you're a corporate taxpayer and you've been tagged with the alternative minimum tax, there's an ability to accelerate that. It was being kind of dribbled out over a number of years. That's going to be completely accelerated. That doesn't affect a whole lot of people. Another one is the deductibility of interest expense. Another one with the Tax Cuts and Jobs Act again is the ability to deduct interest expense was limited to 30% of adjusted taxable income. What's happened is that number has been adjusted upward to 50% now for years of 2019 and 2020 for corporate taxpayers. If you're a partnership, it's only 2020. So again, there's a possible ability there to maybe do some carrybacks and certainly to achieve some additional deductions by amending tax returns if appropriate. On the individual side, and I'm sure these guys will talk a little bit about this as we go, the Tax Cuts and Jobs Act in 2017 limited ability of individuals to claim greater than $500,000 in business losses in a given year. Another one where the handcuffs are off now. So for 2018, 19, and 20, there's no longer a limit. That should open up the floodgates to be able to do some carrybacks to the 5 years prior, claim some refunds from earlier years, as well as be able to offset income that may have been derived in 2018 and 2019. At least in my own practice, I've seen some, most businesses were doing pretty well, particularly in 2019, as we're still working through all those tax returns. Along those lines, New Jersey has said they're extending to all the April 15th deadlines. We're now getting a little bit of wavering. I was on the phone this morning with the chairman of the State Society of CPAs. We're waiting for the legislature to make that all final. So we should hear something. Apparently the vote's on Monday. So we'll get some finality to that in the near term. The advance rebate that's coming out, that's been all over the news, the $1,200 or $2,400 for the couple and the $500 for the dependent. That's all going to be automatic based on direct deposit information that the Internal Revenue has on file from filed 2019 tax returns. If you've not yet filed your 19, they're going to look back to your 2018 tax return. If for whatever reason you're not required to file a tax return, they're going to look at the Social Security database and try and go that way. They tell us they're going to be putting up on their website a portal to be able to provide either updated or flat out just provide direct deposit information so you can get your refund directly. That is not yet up and operational. What also is not up and operational and probably will not be for the foreseeable future is anybody with a change of circumstance. marriage, death, divorce. There's no way to tell the IRS that there's been a change and to redirect those refunds to someone else. A couple other quickies here. So the pension distribution penalty has been waived. So if you're under 59.5, you want to take out up to $100,000 out of your IRA or pension, you can do that without the 10% penalty. In addition, you can actually put it back in whole or part if you do not need all of that money. And there's a time frame to do that. If you're beyond the 59.5, or actually over 70.5, and you're required to take required minimum distributions out of your IRA or your pension, that requirement has been waived for 2020. So if you don't need the cash flow, you can leave the RMD inside your tax deferred plan and let it continue to grow. Conversation to be had with your providers. And finally, the last individual change is a $300 above the line charitable deduction. Yet another gem of the Tax Cut and Jobs Act that eliminated the ability to deduct state taxes, has caused a lot of people to no longer be able to itemize deductions. What this will allow is you'll be able to get a $300 deduction to gross income in computing your 2020 tax return. Those are the main high-level tax law changes. Obviously, I could probably go on for another 2 hours on that, but we don't have that kind of time. Just real quick on a couple of cash flow issues, whether it's your business or your clients. And we're going to take a page here out of the folks who do reorganization for a living. And it's to do a 13-week cash flow. It's to look at your expenses, both mandatory, variable, and discretionary. Money coming in, the money going out. I've been pitching this as like a high school algebra problem. You got to write it down, you got to show your work, and you got to show your assumptions, and you've got to live by it. Week by week, it needs to be updated. It's a little bit of a mind bender, particularly people who aren't particularly financial and oriented, but it does work, and it is a fantastic tool to be able to guide you through the next bunch of weeks as you're able to get the dollars from the PPP, or you're able to manage your workflow as Rich was talking about earlier through this period of time. Talk to the folks at your banks, your landlords, anywhere that there might be an available credit line for yourself. Start talking to people, get that all lined up. Important to remember, it's not just you. You've got to be thinking about your supply chain as well. If this period of downtime has significantly harmed some of your vendors that you rely on for goods and services, you may need to start looking at alternative sourcing of some of your products or the services that you've been acquiring from them, because they may not make it. You need to be thinking beyond you, and that's where that 13-week cash flow can kind of come into play, because you'll be able to understand who you're paying and when. And then finally, I'll kind of wrap up with, think about strategic partners. If you've been substantially weakened, if you've got a solid business model, there's absolutely something that's worth salvaging and moving forward. There may be a strategic partner out there that will see that going concern value and be willing to either partner with you, invest in you, or acquire you in order to maximize some value for yourself. So sorry for the fire hose treatment, but there's a lot there, and I'm happy to chat with anyone offline or afterwards on any of this. Thanks, Joe.
Yep. Thank you very much, Ken. 2-hour tax law presentation, that might be great. We'll talk to Frank O'Mara about it. We're going to go now, and I've already started to get some questions that should get, we should get to them on Frank Huddle's portion of the seminar. If we don't, then I will try to weave them in. But let's now go to the SBA loan state program requirements and eligibility, which will be with Frank, Tom Reck, and Jessica.
Okay, welcome. Today we're going to cover the CARES Act, the $2 trillion federal stimulus package, and in particular, the Paycheck Protection Program, we refer to as PPP, and Tom will be also covering the Economic Injury Disaster Loan, called EIDLs. We're going to cover some of the state initiatives, but we're going to turn now to the main topic, the Pay Protection Program, the PPEs. The first question is, what is the maximum loan that a eligible business or individual can obtain that's in a business? And that is $10 million. The calculation starts in determining the maximum amount of loan, which is 2.5 times your monthly payroll incurred during the 1 year prior to the origination of the loan. There's been much discussion, and as Richard referred to, the change in the guidelines on the SBA, but the guidelines have changed on Monday, the weekend, and yesterday. And the 1 year period, you now have a choice to use either the immediate 12 months and determine the average, and Tom's going to get into that calculation, or the prior calendar year, 2019, which would be all your quarterly tax returns, 941s for that period. You have the choice, but throughout this presentation, our advice, my advice is strictly follow what your lender is asking for. The lenders are using different analysis, and some lenders will use the 2019 period, and others will use the immediate 12, and then others will use both. So under the SBA guidelines, you can use both, but follow your lender. The term of the loan is a 2-year term, fixed rate of 1%. Debt service is deferred for the first 6 months while interest is accruing. The forgiveness program that Tom will discuss, in summary, 75% must go to payroll costs, and the remaining 25% could go to other costs, such as rent. There's no credit requirement, there's no collateral, no personal guarantee. And as we go through this part of the webinar, look at this program, whether you don't fully qualify for forgiveness, because it is a very good loan with the interest rate in the 2-year term. Who's eligible? Pretty much every small business, not-for-profit, anyone under 500 people, law firms, sole proprietors, practitioners. Moving to the next slide.
Frank, let me interrupt you for a moment on a question. If you have a situation where you have 2 firms that were under 500 employees, but then merged earlier in the year, say January 1st, is it their status as of January 1st or their payroll status of last year?
I believe it's as of now. Tom, can you add on that?
I think it would be as of now. Yes, that's effectively what you'd be comparing to.
Okay, thank you.
Okay, so we're moving to, which I just discussed, the eligibility. And to just highlight for Bergen County, it includes all those law firms that are solos or partnerships, LLCs, or corporations. The program has been expanded from the normal SBA's rules. With that, Tom?
Thanks, Frank. So one of the questions becomes, what is a payroll cost? And essentially the way the SBA has defined it, it is to include the salaries of the individual employees up to $100,000. So if you had an employee that was making $300,000 during the last 12-month period on an annualized basis, for purposes of calculating the amount of monies the company would be entitled to by way of loan, they would be limited to $100,000. That will also come into play the amount of money that they're making during the 8-week period after the monies are received from the SBA directly, but we'll hold off on that for a second. Now, it is only the salary that's limited to $100,000, and there are other costs on top of that that the SBA allows you to consider. So those include, if there's any sort of medical leave, sick leave, anything along those lines, that gets encompassed. Employer health insurance is encompassed. Employer payments for retirement, that is included, as well as any payments for state and local taxes that is based on income. So that's not your state withholding, but rather your SUI and your DIS, those sorts of things. That's what that would include. So in essence, it's your salaries plus group health, plus retirement, plus your state and local. That would be the amount of money that would be considered the total payroll costs. Now,
Sorry, Tom, what about PTO or any vacation pay that would have been earned and accrued?
vacation is also included in that number, correct? That's included.
That's
Good
right.
question, thank you. Now, what's of note here is we've been getting a lot of questions about whether payments to subcontractors that you give 1099s to, whether they're included. Originally, the way the language of the bill was, we thought that that might have been the case. The SBA has come out subsequently with additional information, and they've explicitly stated that payments to 1099 contractors are not to be included in payroll. However, the recipients of those 1099s, those self-employed individuals who you give the 1099s to, they can apply on their own for SBA funds. So when you're looking at the individuals that are self-employed, it's the income or compensation to a sole proprietor or independent contractor from self-employment, not more than $100,000 in 1 year. So it's the same concept. It's just instead of there being a W-2, they would be recording it separately on their own. Now, there is a question regarding what happens in terms of partnerships and LLCs. And the question becomes, for many people, if you have partnership income, you don't necessarily take guaranteed payment. So whatever income is that's generated by the partnership just gets picked up on the K-1 of the individual owner of that K-1. So the way we have looked at it is that if self-employed individuals can apply for it, people who are receiving W-2s would be able to apply for the monies. Why wouldn't the same thing hold true for people who have partnership income, for example, that they would be paying self-employment taxes on? So that has been our position. I can tell you that as of today, there was one bank that was not allowing that. And essentially what happened was, and I'm just going to read something that was forwarded to me today, the individual was not on payroll. And in essence, what the bank said was that the partnership, the partners in the partnership would need to apply for a PPP loan on an individual basis starting on April 10th. And the bank themselves admitted that it seemed counterintuitive, but in essence, that was the position that the bank was taking. So in essence, they were stuck with it. So just remember when you're filling out these forms, or if you're questioned, it's the salary component of total payroll that's limited at $100,000. All the other things are on top of that. Next slide. Okay. So now let's assume that you've applied, you've calculated the amount of monies that you think you're entitled to, and let's just say you had a monthly payroll of $1 million, so you got a $2.5 million loan in. It was all approved. You got $2.5 million in. What can you use that for? Well, the first thing really is, when do you have to use it? And that money has to be used in the 8 weeks after receipt of the funds. So $2.5 million comes in, $2.5 million goes out, and it has to be spent on the following costs. Payroll costs, as we just defined, costs for continuation of health care benefits, paid sick leave, medical leave, insurance, health insurance premiums, etc. That's all has to be, that has to be spent, or the money has to be spent on that, excuse me. Payment for interest on any mortgages, that's just the interest portion, not the principal portion. Rent, so obviously that's pretty straightforward. Utilities, which would include your electric, that would include anything to cable provider for purposes of internet, things of that nature. And if you had any interest on any other debt that would have existed. So the money has to be used for those specific purposes. And I would stress here that once the money comes in, that 75% of that money has to be used towards payroll costs. If not, you run the risk of having the loan partially not forgiven.
Tom,
Frank.
Tom,
I'm sorry.
If I could intercede a second. One of the suggestions made last night when we talked, and I think it was Frank who made it, was for practitioners to think about opening up a separate account for this money upon receipt, so that if asked in the future to target or to confirm how you utilize the money, open up a sub account or a separate attorney account or a trust account, whatever you're going to deposit this money in, so that you have a separate trace from your individual account. And I think that's really good advice for all of us to do, no matter how big or small we are.
I may add, when you submit your application for forgiveness, there will be a certification, and the penalties are severe if that certification is incorrect. So the practical solution, if you can do it, open up the separate bank account and you have full tracing of the funds and be quite clear.
The other thing I want to add to what Frank just said is this is an important marketing component that you could do with your clients as well, because obviously reaching out for your clients and talking to them about this particular loan program, or giving that type of advice about segregating the money and also being careful about the fraud aspect of the application is important. And I think it's a good opportunity to send an email or to schedule a call with some commercial or corporate clients to advise them on that, because we're definitely going to see widespread fraud involved in this area, people creating payroll or creating employees, hopefully nobody on this phone call or presentation, but in different fields. So I think it's important, and I think it's a good marketing opportunity to reach out and touch people to be able to give them this level of advice.
Good point. And actually, it's interesting. Frank's suggestion was something that the firm had also been suggesting to its clients as well. And that's not to say if you already have an established payroll account that you're now going to pay the payroll out of this particular account that the SBA funds are going into. Obviously, you could take $1 amount and transfer it over to the payroll account to keep it simple. But you know, to Frank's point, you know, the onus really is on the applicant here. The bank's not under any obligation to check the calculations or replicate the calculations. It's really up to the individual that's applying for the loan. And with that, I think, Matt, we have to go to the next slide.
Well, let me just stop for a second. We did have a question. If a HRA is part of PPP, a health reimbursement arrangement, and does anyone can feel that?
If it's for medical costs, like would typically be provided by an employer, I think that would follow the same principle. I have not seen it specifically listed in the verbiage of the bill, but it would seem to follow the same concept.
And here's an interesting question that I think is applicable to all of us at the moment. Can the money be used towards home mortgage if you have a home office?
I don't know if I'd want to go down that road, me personally. But Frank, what do you think? I would say that also it would really have to tie into allocations, and I would agree with Tom on that. When you certify, you're going to have to certify, and it's going to have to be explicit. So.
I guess maybe the question, and I'm reading it from a post, if someone's only office is their home office, I know the funds are able to be used for rent and for mortgage payments. Would that, I don't know how that would qualify, since it wouldn't be 100%. It would be very difficult, I would think, but I'll leave that to Tom or Frank.
Well, Joe, I think that's a very different circumstance. If there's already been a lease agreement in place, and that's one of the things the SBA is going to look for. They're going to look for lease agreements that are already in place, not something that's being established right around this time prior to filing for a loan or after getting the loan. And if the common procedure has been for the entity, the law firm, to pay another entity that rent, and that other entity is picking that rent up as income, then that would be a different set of circumstances. But just to now say I'm paying myself rent, I would shy away from that. Frank?
Well, you cannot change new rent if the cutoff is February 15th. for both mortgages and other debt obligations and rents. So it has to be in place as of February 15th. If you're speaking totally of the home, as we covered, there's different allocation issues, and maybe we could reach out to the SBA and get some guidance on it. But I think what we said previously is the better course of action.
And then one final question that we're dealing with right now. What happens if you end up with money left over?
Doesn't get forgiven. You have to spend that money.
If it's not forgiven, then you have, the 2-year loan.
Okay.
And that point right there is a practical point, and everybody should look at their finances carefully. In the event you have all your employees working, then you're likely to get 100% forgiveness. However, if you have furloughs and you borrowed the money based on your prior year's monthly, and you're not spending that money on payroll for the 8 weeks, then you will not be able to reach the 100% forgiveness. Tom, do you want to add to that?
No, you're absolutely right on. Yeah, the objective is for the money to be used for payroll, and it's specifically the intent of this is for the money to be used for payroll for people who were making less than $100,000 or less.
But let's say you have a situation where somebody leaves your firm, leaves employment, or left in January to go work someplace else, not as a result of the current situation. So they're included in your payroll from last year, but you haven't replaced that person, and you can't spend it on that person. So you probably would have money left over, so that portion would be non-forgivable. Is that what I'm hearing?
Yes.
Yes.
Okay.
I'd like to just add some policy around this act. The act, the CARES Act, when it was adopted by Congress and signed into law by the president, there was no 75% limitation, and that is something that came out through Treasury and the SBA, I believe, last Thursday. Due to the demand of the program, they then changed the allocation, and their intent now is that the expenses go, supermajority to cover payroll costs.
Yeah, Joe, in many respects, this is unemployment that's being paid by the government to the employer and then out to the individual employees from there. That's really what this bill is intended to do in many respects.
Correct.
That's a good way to look at it. Frank?
Frank,
Okay.
this next slide is you, I think.
Yeah, the next slide is me, and it's called The Next Steps, and it's filled with, the practical real life on taking the first step and evaluating where we are, the rumors that have taken place, which Rich touched upon, the never-changing SBA regulations and guidance. So April 3rd, last week, and if everybody read, was completely chaotic. Some banks did actually issue loans. However, in the most part, the SBA issued their regulations Thursday night, and to say the least, it was pretty confusing on Friday, and then through the weekend, then on Monday. However, at this point in this week, which we were advised on the banking side, that it would be a smoother week and more efficient, it looks like that's what it is turning into. Banks are accepting applications and are processing. The initial banks that got their portals up, and it is pretty much a online application. The banks were accepting applications last week, but that was only to get it into the queue. And now they're at the stage where they're downloading the documents into a secured file and actually processing the application itself. The several changes or key changes were causing some confusion, one being the period in which you compare your prior year's payroll costs. That has now been clarified by the SBA. The recommendation that we could provide here today, that if you're impacted by COVID-19, then your first step is to call your bank, ask the questions that Does your bank participate? If you participate, is the bank actively processing the loans? It's important because the banks are processing, or many banks, I won't say all, but the banks in which I have been speaking to are processing the loan applications for their customers, and particularly with customers that have borrowings with the bank. That's their first step they're doing. So for everyone that is participating, go to the bank in which you have a relationship with. You should compile your records, follow the, I'll say this repetitively, follow the bank's instructions strictly. The SBA has their rules. The SBA will be reviewing the applications. However, there's discretion with the banks with respect to underwriting. So you want to get in there, have your documents as best organized as possible, and to the extent you're answering the questions in which the banks will be asking, that'll move your application much faster. And the bank, I'm sorry?
Frank, what do you believe
that
you've been hearing in terms of timing? I think people on this call are going to be curious. Assuming you got your application in Friday or Monday, what is your best guesstimate on a local bank timing, number one question? And are they giving any preferential treatment to the people who have larger balances in comparison, you know, to small or moderate? What is your thought process there?
My thought is if the law firm has a relationship with the bank, that the bank should react and is willing to react. They were unable to, some of them were unable to do that last Friday, in particular, and a major New Jersey bank, and a couple others. That has changed Sunday night, where the emails were coming out or the portals to their customers to here's the information that you need. From a timing standpoint, I'm hearing in part that this will be expedited, and going back to the point I previously made, that if you submit the documents in the order in which the bank has requested, that will facilitate the underwriting process at the bank. The bank.
Frank, let me just stop. Frank, sorry? I'm sorry. Let me just stop you for one moment in terms of making the application and getting the loan accepted. I had heard from a practitioner yesterday that a bank turned him away because he didn't have a business relationship already with that bank. Are you hearing that? Are all banks taking applications from whichever firms come in the door, or what's the situation?
Joe, that's absolutely correct. Many banks are not taking applications if there's not an existing relationship. Other banks are suggesting that if you come to us with a new application, you're going to have to shift your relationship. So you said it on the other side, Joe. It's exactly correct. If you don't have a banking relationship, then reach out to us or reach out to the SBA. There is a link on the SBA site for banks. But Joe, I have heard that the banks are not accepting applications. They're starting with their own customers first.
That particular practitioner told me, and I hadn't looked at the sites, that he went to the SBA site and was able to make an application directly through that website. I assume that's correct, but I haven't seen it.
Yes, yes, it is. I'm unfamiliar. I don't know if Tom's familiar or anybody on the panel. I'm unfamiliar on the processing of that, but information has to go into that. And it's unfortunate, but there's a massive overload of these applications, and the banks are overwhelmed, and other banks they're all doing it, but they need a high-tech platform to process these applications. Once it settles down.
Hey, Joe.
Hey, Joe. Oh, yeah, go ahead.
If let's back up a second though, too.
Sure.
I think maybe the banks are being treated a little bit unfairly here. I mean, one of the things that I'd like people to remember is that this verbiage, was not released until last Thursday night, and the banks were expected to start processing loans on Friday morning. I don't know how they were expected to do that when there was such ambiguity with what was provided, even in terms of the interim guidance to which I'm referring to from last Thursday. So the banks needed to be able to get themselves up and running. The banks were also reliant to a certain extent, in many cases, on payroll companies. And unfortunately, the payroll companies were getting the calculations wrong. So for example, the point I was making about just the compensation being subject to $100,000, some banks were taking the salary plus the health plus whatever, and then limiting that whole thing to $100,000. Others were adding in or subtracting out employer or employee portion of FICA taxes. So there's been a lot of confusion here. And you know, look, I'm not a stockholder in a bank or anything, but you know, this whole process has been, you know, it hasn't been handled so well from the top, for lack of a better way of putting it. So the banks were receiving applications on Friday. To my knowledge, many of them were accepting the applications, but really weren't doing anything with them. What day is today? Tuesday? I don't even remember anymore.
Today's
All the
Tuesday.
days.
Today's Tuesday,
Yeah,
or some people call it
yeah,
Blur's Day.
Blur's Day, exactly. And I know that the SBA, there's a platform that the banks use to take the information to access the SBA website. That actually crashed yesterday. So there have been delays, and I just don't want people to feel like, you know, the banks are treating them unfairly or anything along those lines. I think they are truly doing the best they can with the circumstances that they were given. Frank, would you
No,
agree? Or?
I would agree with
that's a
that.
good point.
Sorry?
It's a good
Go,
point.
Joe.
I was going to say, it's a good point. The question and that practitioner's issue, I don't think was meant to be a hit on the bank. It was meant to, and we're not mentioning any bank's names. It was really meant to say, well, what are our practitioners? What are our bar members? What are their options when they're looking for these loans? If they don't have it, what can they do? They can go to the SBA. They can certainly call their tax accountant or wherever else they're dealing with to try to help make the application for them. But that was an issue, right or wrong. And you know what, I don't, from the top down, I'll even go further. I think everybody is doing the best they can with a situation that nobody really expected or has had to deal with before. So we all appreciate it. We certainly appreciate the PPP, but we're all trying to work through it.
I'd just like to add, everything Tom said, you said is absolutely correct. The practitioner should reach out to his relationships, particularly his accounting firm and others, to identify a lender to participate. But what Tom said, the banks are doing their best and are processing loans as of this point. It is recent as either last night or this morning that the SBA has issued what they call frequently asked questions and answers, and that's providing further clarification in the program. And the banks are looking at their guidance as a lender, what they have to do, and Tom's exactly correct. They need that information, but that information is now coming from the SBA, and it should get better as each day goes forward.
Frank, I just want to back up because someone also sent in a question. I'll direct it to Tom. It's something that he was just dealing with, I think, moments ago, that probably a lot of firms are dealing with. What if prior to the PPP, you've already reduced your payroll because you saw this coming and cash flow obviously was difficult. But now that you've applied and you're given the SBA loan, should such a firm return to normal payroll, or how would they deal with that past reduction?
Well, someone say something? Okay. So actually, why don't I defer on answering that question, and let's go into the next section of the next slide, because we're going to start addressing the loan forgiveness. How's that?
Yeah.
That
Before we
sounds
do that,
perfect.
I want to cover a point to bring.
Oh, go ahead, Frank. Sorry.
Yeah, sure.
Go ahead.
And this is, I received countless phone calls, and all of us, I believe, have, on whether there is sufficient funding for the program. There is a fair degree of anxiety that, you know, some will say, just take the Northeast and you spent the $349 billion. To step back, this PPP program is funded with $349 billion from the stimulus package. What has occurred on that anxiety, and what I would like to try to ease everyone on the phone that does have those concerns, the government is pushing to recognizing this issue, members of Congress and the President have made comments. But yesterday evening or late afternoon or evening, the Federal Reserve, which is very significant, announced that they're creating a new program for the PPE program, the loan program, that will allow banks to make more loans in excess of the $349 billion. So that program, where the details are not out as of yet, the Federal Reserve is going to be in a position to have its agencies, similar to mortgage-backed securities. I don't know exactly how it's going to be done, but we'll be, moving those loans and then releasing the banks so they have more lending capability. So the $349 billion, based on the Federal Reserve's announcement yesterday, is very good news. And stay tuned and see how that develops.
Okay. So let's go into the next slide if we can, and we're going to start talking about the loan forgiveness piece here. And I would just like to point out before I start that the original bill, and this is basically the pertinent sections of the bill that pertain to this. There is still supposed to be additional guidance forthcoming from the SBA. The original bill talked about a number of different things, including full-time equivalent employees that the interim guidance did not address. And that's the same interim guidance that said additional guidance will be provided. So the information that I'm going to share with you over the next 3 slides, I'm hoping will be accurate when further guidance is released, but I'm just warning everybody that there could be some differences at the end of the day in the way the calculations will be presented. So let's start. We look at the next slide, or this slide, excuse me. What the SBA is asking you to do in order to have the loan forgiven is in the 8 weeks subsequent to receiving the loan or the origination of the loan, they're asking you to use all that money. And they're asking you to use it for specific purposes. And those specific purposes are the payroll costs that we discussed, interest on mortgages, rent, utility payments. And again, to reiterate, and I hope I don't sound like a broken record, the 75% of the total payments should be on payroll costs. There's another grant that someone can receive. It's called the EIDL, economic injury. If you receive that money will actually be applied and reduce the overall forgiveness that you would receive from the SBA. And we'll talk about that in a little bit. Now, the loan forgiveness is affected if you reduce the number of employees or their compensation. So it's both. If you reduce employees or you reduce their salaries, both can have a negative impact on the amount that will be forgiven. Next slide, Matt. Okay. So the amount of the loan forgiveness shall not exceed the original principal. Now, the interim guidance also indicated that the amount of the loan that could be forgiven would be the original loan plus the interest. So even if there was a small amount that you didn't use towards those individual costs, if it included the interest, then that would be covered as well. The reduction of forgiveness is based initially on the full-time equivalent employees. So you were looking at the average number of full-time employees during the month during the covered period, and you're dividing that by either February 15th of 19 through June 30th of 19, essentially a year ago, or from January 20th of this year through February 29th of this year. So let's break that out a little bit. So if last year you had 18 full-time equivalents employees, and this year during that 8-week period you had 15 full-time equivalent employees, essentially you're talking about 15 divided by 18 is about 83%. So if you had a $2.3 million or you spent $2.3 million, 83% of that is the amount that would be forgiven. So $1.9 million is the dollar amount that would be forgiven. There's a second component to this, and that is the reduction of salaries and wages. And any reduction in total salary of any employee, and that's unusual language because it does specifically say any employee, during the covered period that is in excess of 25% of the total salary during the most recent full quarter before the covered period. So this only applies to people that are making $100,000 or less. So when you were calculating the amount of loan, you were limiting everybody to $100,000 plus the benefits, taking the monthly average and multiplying it by 2.5. That was your loan amount. Now what they're saying is, if you had an employee that had their salary reduced, there could be a recapture. So if, for example, let's just say you got a loan of $93,000, $94,000, let's say, is the amount of the loan. And during this 8-week period on an annualized basis, you had an employee that was earning $75,000 and now they're at $40,000 on an annualized basis as a result of you cutting their salary. That's a 47% reduction. So what you're then doing is you're comparing that, as it says, in excess of the 25% of the total salary. So 47% minus 25% is 22%. 22% of that $75,000 would be $16,250. So if you got in $93,750, you subtracted out the $16,250, that leaves you with a $77,500 loan balance that would be forgiven. It's a bit complicated. I apologize that it's as complicated as it is. Unfortunately, it's the way the law was written. Now,
hey Tom, can you get into the question that you and I talked about and was brought up earlier in our phone call about the person that has been reduced from 120 and or 130 area, as to how that affects this equation, if at all?
Yes, for purposes of the loan forgiveness, if you were over $100,000, you don't come into play here for the loan forgiveness, which actually works to your benefit. Because if you had someone that was making $300,000 and now let's say they're making, $100,000, okay, you just reduced their salary by 2/3, and that would negatively impact you in terms of the loan forgiveness. So again, when you go back to that idea of these monies are intended to be spent, again, on folks who are making $100,000 or less. So it's really geared towards those who are making that, and anyone making over $100,000 does not come into play for purposes of recalculating the loan forgiveness. So that's out. Now,
Tom?
Yes, sir.
If you have a situation where prior to obtaining and applying for the PPP, a firm reduced its the salary of its W-2 employees by 25, 35, 40, whatever percentage it is, so that their annualized income for the two payroll periods or one payroll period before getting the PPP is reduced from what it was last year. Is that part of the calculation, or only when you annualize the 8 weeks which you're using those funds?
There's actually a time frame that you would look at, if I remember correctly, and Frank, maybe I think it was from February 15th of 2020 through April 26th of 2020. That's if you've reduced people during that time frame, but you bring them back up to the head count that you had prior to the loan coming in. I think it would be the first quarter. If you bring the head count back up by June 30th, none of this applies. That's my understanding of the law. You agree, Frank?
Yes, I do, Tom.
Perfect.
I'm also talking about the salaries too. So if you cut 25% of the salaries of workforce, but then you brought them back up to 100% because you got the PPP, that prior cut wouldn't affect your forgiveness because you're going to pay them out on a regular, on an annual basis, correct?
It could. The question would be, if you receive, let's just say you got $1 million in, and as a result of those cuts, you only spent, to your question earlier, you only spent $800,000, then that would negatively affect you because you'd have that 200, you'd have that amount of money that.
That's not what I was asking, Tom. I was asking if you cut and you only cut for 2 payroll periods or a payroll period before you received the PPP, Once you get that money, you bring everybody back up. So their annualized period during the 8 weeks you're paying out the PPP money is equal to what it would be for your 2019 payroll.
Mhm.
The fact that earlier in the year there was a reduction, is that factor in, or is it only that you pay the people pursuant to what their payroll status was in 2019 during the time period you're paying out the PPP funds?
I think what you're trying, yeah, I think it's the payroll up through 2019. But remember, if you've to my point, if you've reduced their salaries during this period and you've got funds left over, and that's why I answered the question the way I did. If you have funds left over, that would negatively impact your potential loan forgiveness. That's I agree with your point, but also remember, if you don't spend that money, you can negatively impact your loan forgiveness.
If I just
Okay.
may add to separate the tests here on the determination on the ratio of what's forgiven, that is a June 30th application. Tom did mention that. I just want to highlight it because it does get more confusing.
That's correct. And Frank, I think the next slide is you, right?
Okay, the next slide goes forth on the documents that are requested. I have covered several of these points. However, I want to emphasize this is effectively a two-pronged application. The first step in support and providing the documentation, which was discussed, is the application itself. And there's certifications on that application that everybody should read carefully. And then on the forgiveness, in which Tom just went through, that application would be submitted by the borrower some period after June 30th. And there will be documentation, and stay tuned on the amount of the documentation. It can include, payroll records. It could also include canceled checks. We don't know at this point. Maybe Tom has some more insight on it. But that documentation will have to be provided. And what's not in this PowerPoint, and it's an important point, you will be certifying that your practice is impacted by this COVID-19, and these funds are needed to continue your business. There are businesses out there, not our law practice, that actually are benefiting because they're providing critical resources to those that are in critical need. But that is a separate certification. So the documentation, the FTEs, the supporting documentation, include checks. The banks could rely on that. We've already mentioned the separate bank account. If you can use that, we would recommend it. And then any other documentation that the lender may require. But from this period to the date of the forgiveness, the SBA will most likely will be providing more guidance. So stay tuned.
Frank, just I have to apologize, but I have to interrupt for a second. We're more than halfway through. We started at 3. It's about 4:15. The attorneys listening, and I know some people want their CLE credits that are being provided. Here is the code. The code is Brandy, BRANDY. Brandy. Back to you, Frank.
Actually, Matt, could we go one more slide and I'll pick up? All right. So there is another component of availability of money from the SBA, and that's what we've been referring to as the EIDL. It's the Economic Injury Disaster Loan Program. And in essence, what EIDL is intended to do, it's intended to help businesses that are desperately in need of cash. So it's businesses that have a large amount of accounts payable, maybe has had a real stoppage in terms of revenue recognition, things of that nature. And the maximum amount of monies that you can get through this program is $2 million. The loan amount is actually determined by the SBA. So what happens is, unlike everything that we've been talking about up until this point, the EIDL program, that loan application is actually directly with the SBA. So you will go online. The easiest way is to go online, fill out a form. It's actually a very short form. It's going to ask you your gross revenue. It's going to ask you your cost of goods sold. It's going to ask you some specific things. And then it's going to have you sign off your certifications that you haven't been convicted of any crimes, things of that nature. You'll file with the SBA directly. The interest rate for businesses is 3.75%, 2.75 if you're a not-for-profit. Term is up to 30 years. And again, it's for bills that could not have been paid otherwise as a result of the COVID disaster. The SBA is waiving the credit elsewhere clause, meaning that even if you were trying to get an SBA loan, but you could get a loan from a bank, you would not be able to get it through the SBA. That's been waived here. No personal guarantees for any loans under $200,000. And you don't even need to be in business for a whole year. As long as you were in business as of January 31 of 2020, you're good. In many instances, what the SBA will do is they'll actually calculate, they'll give you money based on your credit score. I've known a couple of people who have applied for this. I've not known anyone to hear back from the SBA just yet. One nice thing about this is, we go to the next slide, Matt. There we go. One nice thing about this is there is an emergency grant of up to $10,000 that is to be paid within 3 days after applying with the SBA. And again, just to reiterate, if you're approved for this program and you get it, and the grant would be used to reduce the overall loan forgiveness amount later on. And how to apply, and I'm not going to spend a lot of time on this because I realize it's 20 after 4. How to apply for the loan. As I said, main way would be to go through the website, and then the information that you need is listed below. Form 4506, your federal income tax returns. If you don't have the most recent one, don't worry about it. Print a balance sheet and an income statement off a Quicken or whatever it is you use. Monthly revenue, liabilities, and it's a pretty straightforward process. Frank, back to you.
Okay, thank you, Tom. We're turning now to the state initiatives, and it's what we have outlined there is the Small Business Emergency Assistance Grant Program, direct grants up to $5,000. Unfortunately, we received a notice that the funds have been exhausted. We look forward to our state government to provide some additional funding on that. The Small Business Emergency Assistance Loan Program and the Small Business Emergency Assistance Guarantee. The first one has direct loans up to $100,000 for up to 10 years of flexible terms. And then the second one, the emergency assistance, is similar. What I would recommend to everyone on this call that, and Matt, do you have the link for the COVID-19 New Jersey business? Our state government and our governor has a tremendous resource on njgov19.com. And if we don't have the link here, you could just go on that website, type in business, and it will take you to the various business programs that the state is offering. It's comprehensive. It's a tremendous resource, and I would suggest anyone that's interested is to go to that link. And that would also include the community development finance, the CDFIs on the emergency loans and guarantees up to $75,000, as well as the other initiatives. Again, we're focused today on the PPPs, but our recommendation here is go to those sites. If anybody has follow-up questions now or want to send them to Joe, we'll be happy to answer.
Frank, I have Frank and Tom, I had a handful of questions come in. I think some have been answered, but we'll just go through them quickly till we get to then we'll get to the next section. So I want to move along. Will the loan forgiveness be a taxable event? And my understanding is it is not.
No, it is not.
Correct. If you're a solo self-employed individual who draws no formal salary but is a 1099, is that person eligible? And I think Tom, you answered that earlier, that person, that 1099 should make his or her own application, correct?
Correct. And those will be accepted by the SBA starting this Friday.
Okay. And can the PPP loan be used to restore reduced salary from the prior payroll period if the reductions were because of COVID?
If it's being used towards salary, I don't see an issue with that. No, Frank?
I believe you're correct.
Okay, I did also get, as Rich and I said earlier, we were in contact with Josh Gottheimer. We've gotten some information. I have to get it support for it, rather than just going back and forth on my cell phone. But it looks like the interpretation is that mention of sole proprietorship, partnership, and LLC should provide coverage of K-1 filers. So that was something that just came across my phone. So that's helpful, I believe, to a lot of K-1 people out there who may be listening.
Yeah, if I may add, for your business clients in multi-states, there's no taxable event on the forgiveness. In New Jersey follows federal, but if you have clients in other states, you should just take a look at that.
Yeah, and the email that I got regarding that K-1 filing also comes with, of course, some legalese that the guidance and rules issued by the Treasury SBA may change in the future. So even this is just guidance at this point.
That's correct.
Right.
Yeah.
Rich, is that correct?
That's correct.
All right, we need to, I think, move on to the next presenter, and we have.
Thank you.
I don't know if go to Dennis right now or Jessica. Jessica is going to be speaking about fraud issues, I believe, and Dennis is going to be speaking about insurance and force majeure. So fraud. So I think we're going to Jessica.
I think if we go to insurance and Dennis can talk first, and mine kind of plays into what he's speaking, that would probably flow well.
All right, so Dennis, we'll turn it over to you. Thank you.
All right. Thank you. Let me, as far as insurance coverage is concerned, let me start by stating the obvious, that read your policy, because each policy can be different. The language in policies, particularly with the scope of the coverage and exclusion, can vary insurer by insurer. My sense is that given the amount of the business interruption losses you can expect as a result of the COVID-19 pandemic, that there's going to be a substantial amount of claims being noticed to insurance companies. And these insurance companies are going to be reluctant to pay those claims based upon the language in many of their policies. And from a policyholder's perspective, while we face an uphill battle, I believe, in getting the insurers to accept these claims, there are arguments that can be made, and the hope is that courts, particularly in New Jersey, will look for ways to find coverage if cogent arguments can be made. Business interruption. The policyholder typically has to demonstrate the existence of a covered property damage, and can only seek insurance coverage for business interruption losses flowing from that property damage. The classic example would be a policyholder seeks business interruption damages because losses from a fire to their facility. You know, a fire would be covered under the first party property damage coverage, and the insured can get whatever business interruption losses were resulting from the fire. Here, in this unique situation, insurers will argue that, well, there's no physical loss, so therefore there's no coverage. There's a few cases in New Jersey that would help defeat that argument, that you don't necessarily have to have the physical structural damages to trigger the physical loss coverage under your policy. One important thing is direct, the phrase direct physical loss or direct physical damage is typically undefined in insurance policies. So if you can fashion an argument that it's ambiguous, courts will bend over backwards to find that, read it in a manner most favorable to the policyholder. There's two cases, and I'll just talk about them briefly in New Jersey. One case where the homeowners found E. coli bacteria in their well, and they rendered the house non-functional and uninhabitable, and they made a claim against their insurer for physical damage to the property. The insurer said, well, there's no physical damage to the property, but there's no structural damage, and that's what the coverage was intended to be. And the court ultimately held even if there's unforeseen damages, if the bacteria made the house lose its essential function or rendered it uninhabitable, there would be coverage. There's also a district court case out of New Jersey where they were putting in a refrigeration system and there was an ammonia leak. And the ammonia leak into the facility caused the facility to shut down for several weeks. And they sought to have they sought to claim business interruption damages. And the insurer again said, well, no structural damage, so therefore no coverage. And that court ultimately found coverage for the policyholder, saying that the direct physical loss or damage was undefined in the policy, and cited a lot of out-of-state courts that said courts considering non-structural property damage have found that buildings rendered uninhabitable by dangerous gases or bacteria suffered direct physical loss or damage. So the issue here would be is whether the presence of the COVID-19 virus in a commercial setting constitutes direct physical loss or damage. I think the science, and if you would show you that the presence of coronavirus on desks or office equipment can constitute direct physical loss or damage. Now, it's not as clear as the E. coli bacteria case or the ammonia case in those cases that I refer to, but I think in the COVID-19 setting, you'll look at your business, like your law firm, where there are employees or employee family members that contracted the virus. Because if you had, that means the virus could be in your office building. Also, I believe, and I think it'll probably need some type of expert testimony, that there's a certain amount of individuals that are asymptomatic carriers of the coronavirus, but we don't have adequate testing yet to see, if you tested positive without symptoms. So that type of argument can be made that my office was rendered uninhabitable because we didn't know who was asymptomatic. We didn't know how the virus was distributed within our office, and it made our office, the functionality and the basic use of our office non-usable. And there's nothing in the insurance policies that requires the direct physical loss or damage to be visible. And the cases I cited earlier should support that. So my hope is that we're going to face an uphill battle in policyholders' will in obtaining coverage, but I think there's arguments that can be made, and hopefully arguments that can be made supported by science down the road, that insurance companies may be compelled to cover these claims. I would doubt that any of them, absent extraordinary policy language, would just accept the claim as is without some type of dispute resolution, whether it be by court, mediation, or arbitration. But what I would recommend is people read your policy, put your insurer on notice, say we assume we're going to have business interruption claims under the policy, where we'll follow it up with data supporting our loss. But once you put the insurance company on notice, they're required to respond to you in writing, citing specific policy provisions as to why they're not providing coverage, and that will at least inform you as to the scope of what their position will be, and it will also inform you as to how to take future actions and what actions need to be taken. The second thing I'm going to talk about is virus exclusions or infectious disease exclusions. These became popular after the SARS epidemic in 2006, 2007, where policies specifically excluded any damages arising out of bacteria or viruses. Obviously, if that's in your policy, that's almost an insurmountable hurdle to overcome to obtain coverage. But there's two kind of outside of the box ways of looking at it. The first way is there's legislation in New Jersey that's been presented that would require insurers to cover business interruption claims for businesses of 100 employees or less, even if the particular insurance policies contained a virus exclusion. So I think the bill was presented on March 16th, 2020. I'm sure there's a lot of give and take behind closed doors with the insurance industry, who's particularly not going to be fond of this type of legislation. The second argument that can be made, and I don't know the viability of it yet, is New Jersey recognizes a principle of regulatory estoppel. When the insurance companies presented this virus exclusion to the Department of Banking and Insurance, they had to make representations to the state board as to the scope of these exclusions. Did they clarify a policy? Did they change the policy? If those representations before the board were not truthful, there's an argument that they can be stopped from raising the exclusion to defeat coverage that insureds seek. Interestingly, other than New Jersey, Ohio and New York have submitted similar legislation, and in New York has taken it a step further. They've asked the insurance companies to provide to the legislator all information they presented to the Department of Banking and Insurance concerning the scope of this exclusion. So in my practice, I've already sent out Oprah requests seeking to obtain all information that was presented by the insurance companies in 2006 when they sought approval of this virus exclusion in the state, just to wrap my arms around the representations they were making to the public bodies. Civil authority coverage, it generally provides that if an order of civil authority limits or prohibits access to an insured's location, there's coverage provided such order is the direct result of physical damages of the type insured at the insured's location or within a specified distance from the insured's location. An argument can be made that the widespread coronavirus, in particularly Bergen County, that was hit hard, rendered a lot of the commercial establishments uninhabitable because of, for reasons similar to what we would argue would be coverage under your commercial liability policy that I spoke about earlier. The thing you have to be careful about the civil authority coverage, a lot of times there's sublimits to that, so the amount of money you can recover is a lot less than the policy limits. And secondly, a lot of policies require a waiting period that's really not applicable here. That they may say you have to wait 3 to 5 days before you're even able to assert a claim for coverage. I recall reviewing, there was one case where the Michigan governor ordered curfew after widespread riots, and some of the businesses that claimed business interruption of the civil authority section of the coverage were able to get coverage under that. Finally, and very briefly, the force majeure, act of God, is a contractual defense. You know, it usually force majeure concerns unforeseen natural phenomena, floods, fires, earthquakes, other natural disasters. What I would say for that is look at the force majeure provisions in contracts. It could possibly exclude performance by both sides. It could possibly exclude, allow delay in performance by one side, but in particular, it's you'll have to read the contract, and that'll inform the legal arguments that you have. But just to put a circle on this again, I would recommend that anyone that has losses, put your insurance company on notice. I mean, anticipate that they'll probably reject the claim, but you'll at least be informed of why they're rejecting it, and then you could decide what next steps you want to take.
Thank you,
I think
Dennis.
Jessica is going to speak a little bit as to calculating some of your damages for business interruption losses.
Yeah, Matt.
We have some time left. Obviously, we have Jessica and Jim to get to, so let's do that.
Yep. So as Dennis spoke about, and Matt, if you can go to the next slide, most people have been really focused on whether there is coverage or not. So what I wanted to touch upon very briefly is there's also an issue that if there is coverage, these claims are anticipated to be significantly more complex than your ordinary business interruption claim. And what I mean by that is there's some considerations that are going to be relevant to these COVID-19 losses, which really haven't existed with other types of disasters like fire that Dennis mentioned. I think that, one of the main arguments that insurers are going to make in regards to these COVID-19 claims is that many businesses suffered a decrease in revenues during their closures, but that decrease was actually mitigated or recovered upon their reopening. So essentially, the insurers may argue that the decreased revenues weren't actually lost, but instead they were just pushed into a future period. And an example I like to give that I think helps people see the difference between what I'm talking in is that a business interruption claim resulting from a typical property damage like a fire, and one resulting from COVID is an auto dealership. So although these concepts I'm going to talk about could apply to different types of revenues, even including legal fees, I'm using an auto dealership as an example just because it's a concrete example and it's something that's a little easier to understand. And so if you assume that auto dealership had a fire and closed for a period of time, in an ordinary situation, during that time, the individual is just going to drive 10 miles up the road and they're going to purchase a vehicle from another dealership. So in that instance, it's fairly clear that that dealership lost the sale. When we now fast forward to COVID, the issue is the closures were widespread. So that auto dealership is now closed based on a government mandate, but so is every other auto dealership in the area. Sometimes, within multiple states that are also closed. So the individual that was now on the market for that vehicle couldn't just drive 10 miles up the road and get it, but instead they had to wait until these dealerships opened. So I think for that reason, the insurance companies are going to come back and argue that there wasn't really lost, all these revenues weren't lost, but it really created a pent-up demand, and that there wasn't a loss of revenues because of the closure, because they had this opportunity to mitigate upon reopening. So, I mean, very briefly, that's just one of the issues that we think are going to come to light. On the other side, the business owners will have alternate arguments that we couldn't mitigate because we're not big enough and we didn't have the capacity to handle, those past loss revenues as well as our current sales. So the point here is just that these are really difficult concepts, and if there does end up being some form of coverage, the business interruption claims are going to be very complicated, and they're going to require a significant amount of documentation. So on the next slide here, and in the interest of time, I'm not going to go through these in detail, but on the next slide, there should be an outline of the general types of documents that should be maintained. And if anybody has any specific questions, they can reach out to me in regards to their particular business.
Okay, I think Jim, you're up.
Yes, thanks, Joe. And thanks to all those who stayed with us here. Can everyone hear me okay?
Yeah, could you, if you can, put on your video, please?
Oh, sorry.
There you go.
Sorry about that. Okay, so I will try to run through my section quickly as well, because I know we're getting towards the end of our program here. But I'm going to speak about two different federal bills that have passed in response to the coronavirus pandemic. The first being the Families First Coronavirus Response Act, which provides for paid sick leave and paid family leave for certain categories of people. And then second, I'm going to speak about the sections of the CARES Act that have expanded unemployment benefits for individuals who meet certain characteristics. So the first one, and this one passed earlier on, was the Families First Coronavirus Response Act. And in broad terms, it requires private employers with 499 or less employees to provide paid sick leave or expanded family and medical leave for reasons, specified reasons related to COVID-19. This does not apply, and probably this is not going to be relevant for most of you, but businesses with 500 or more employees are not subject to this law. The law became effective April 1, 2020, and it does not apply to any leaves that were taken before that date. So even though the law was passed before that, the DOL has taken a position that became effective on April 1st, and any leaves that occurred before then were not subject to this law and would not qualify for the credits that employers can receive under this law. The Act provides that employees of covered employers are eligible for, and this is the first category, 2 weeks or up to 80 hours of paid sick leave at the employee's regular rate of pay, where the employee is unable to work because the employee is quarantined or the employee is experiencing COVID-19 symptoms and seeking a medical diagnosis. So that's 100% pay for 2 weeks for the employee's own symptoms or illness related to COVID-19. The next category is 2 weeks or up to 80 hours of paid sick leave. And even though they're calling it paid sick leave, it's really actually more like family leave or other things. And this one is only at 2/3 the employee's regular rate of pay because the employee is unable to work because the employee has a bona fide need to care for an individual subject to a quarantine. The employee has a bona fide need to care for a child whose school or child care provider is closed or unavailable related to COVID-19, or the employee is experiencing a substantially similar condition, and that will be defined by Department of Health and Human Services. So that's the second category, 2 weeks for those categories at 2/3 of the employee's regular rate of pay. And then finally, there is an expansion of family medical leave, paid family medical leave for up to 10 weeks at 2/3 of the employee's regular rate of pay. And this only applies to employees who have been employed for at least 30 calendar days. And the only category this applies to is individuals who are unable to work due to a bona fide need for leave to care for a child whose school or child care provider is closed or unavailable for reasons related to COVID-19. That probably would apply to nearly every employee in the state of New Jersey, considering all schools are closed in New Jersey. So assuming that the individual and the employer meet the coverage requirements, people could be eligible for this 10 weeks of paid family leave at 2/3 pay. There is a limited exception under the law for small businesses, businesses with fewer than 50 employees. They may qualify for an exemption from the leave requirements if the leave would jeopardize the viability of the business as a going concern. And the Department of Labor has recently issued proposed regulations and guidance explaining what their enforcement position on what that means to be jeopardizing the viability of a business as a going concern. So those are the general categories of who would be eligible for leave. I think most people have probably seen by now, employers that provide this, paid leave or paid family leave under these programs are eligible for credits, tax credits that, I can go into the details of those, but should basically allow the employer to recoup most, if not all, of the costs of the leave that they have paid out. And there could be some timing issues there, but the credits are, meant to, cover those costs for employers. So now I'll get into the second part, which is the expansion of unemployment under the CARES Act. The CARES Act, provided some pretty broad expansions to what would have been available to the individuals, certainly under what would be available under New Jersey's current unemployment program. Eligible workers are now able to collect unemployment benefits for up to 39 weeks. In addition, eligible workers can receive an additional $600 above and beyond what they currently make or currently would receive under state unemployment. And that benefit lasts for up to 4 months. In addition, workers who have exhausted or will exhaust their unemployment benefits are eligible to collect additional benefits under this program. The Act also provides funding for states to waive any waiting period for receiving unemployment benefits. So in New Jersey, there is a waiting period, but the federal government is going to provide funding for states to waive that requirement. It's important to know that individuals are not eligible for benefits if they have the ability to telework with pay or they're receiving paid sick leave or other paid benefits. Those individuals would not be eligible for any unemployment assistance. This could, also relate to, employees who have been furloughed, or employees who have had their hours reduced or their pay reduced below a certain point could be eligible for unemployment under the state system, and they would also potentially be eligible for this federal enhancement if they meet the eligibility requirements. I'm not going to go through, all the eligibility requirements here, but they're similar to the eligibility requirements for paid sick leave or paid family leave, and they're spelled out in the statute. But generally, in general terms, people who are impacted, lost their job or are unable to work because of COVID-19 can receive this additional federal unemployment. The other important area to note, I think, is that the CARES Act expanded unemployment to cover those who would traditionally not be eligible for unemployment benefits, notably individuals who are self-employed or independent contractors who generally would not have been eligible for unemployment benefits are now eligible under this program. In addition, individuals seeking only part-time employment are now eligible to receive assistance under this, and individuals who do not have sufficient work history could be eligible. The Act also relaxes the actively seeking work requirement, where the individual is unable to search for work due to COVID-19. The DOL did recently issue some guidance on some of the things, and there's a lot in there. I'm not going to go through all of it, but I think one in particular, the definition of self-employed individuals could be pertinent to some of you. Self-employed individuals means individuals whose primary reliance for income is on the performance of services in the individual's own business or the individual's own farm. These individuals include independent contractors, gig economy workers, and workers for certain religious entities. So I think that's a pretty broad definition for self-employed individuals that that could apply to a lot of people. The final thing that I'll note is that the CARES Act does not mandate any way for the state to change the way that they calculate unemployment taxes going forward. So employers that do lay off employees may have their unemployment tax increase in the future. The unemployment tax rate is a function of a couple different factors, but one of them is the amount of claims for unemployment that has been made against that employer, and the amount of money that the employer has contributed to the unemployment system. So if there are an increase for that employer in the number of claims, could result in increased unemployment taxes going forward. And then the final thing I'll note is that the state, New Jersey, is still working through these things and still trying to work with the federal government to get more guidance on it. I was on another webinar with the New Jersey Commissioner of Labor last week, and he said that they're still waiting for additional guidance from the federal government. But his advice was for everyone who thinks they may be eligible to apply right now, even if they get denied initially, that will at least get the process started and get their claim kind of going through the system. And then, once things kind of get up and running, hopefully the claims should be processed appropriately. So that was his advice for now. And I think that's about all I have, unless anyone has any questions.
James, we do have a question that came in for you. The question on unemployment that we received is, in New Jersey, there is a maximum unemployment payment of $713 per week. If you make $1,000 per week, do you get an extra $600 or an extra $287 per week? My guess is it's the $287, but
well, yeah, that might appear logical, but no, you would actually get the additional amount, the additional $600 on top of what you would have received above. So it does create kind of a unusual situation where an individual could earn more under unemployment than they would have been earning while being employed, which may create some different incentives, but these are limited programs, so it's not going to last forever.
Okay. I did receive via email. Let me just get to it, some more questions. If I terminated an employee before applying for the loan, can I hire a different employee in order to maintain the same level of average monthly salary levels? In other words, do you have to rehire a terminated employee, or can you replace them?
I believe you have to, if you replace the FTEs, that'll be the test. Is Tom still there?
I agree. Oh, I didn't realize my webcam's not on, sorry.
Yeah, pop yourself back up, because a lot of these questions, Tom, probably will go towards you. The requirement to maintain salary levels and FTEs is only through June 15th, 2020, correct?
June 30th.
Is it permissible to reduce both after that date without impact on the loan forgiveness?
Yes.
Also, this goes with the EIDL loans. He thought the person was asking whether the EIDL loans, not grants, are included in the PPP loan repayment amount. Isn't an EIDL grant separately granted after applying for a PPP loan not considered in the PPP repayment amount?
The EIDL can be rolled into the PPP, but the only amount that would be forgiven would be the PPP portion.
Does it reduce the forgivability if you take EIDL? Is your PPP portion reduced by how much EIDL you take?
Correct. The forgiveness is reduced by that amount.
That is actually, we have, just so everyone sees, we have almost everyone who started with us is still with us, which says about how important it is, this information is to us. So I appreciate everybody sticking with us. If anybody has questions, they can type it into the chat box and we will get to them. But at this point, there are no other questions.
Joe, may I add? Joe?
Sure, and I did get another question, but go ahead.
Yeah, I know. I just received a news update The New Jersey Economic Development Authority rolled out the specifics of how businesses hurt by COVID-19 can apply for the $10 million loan. It was exhausted and it was just reinstated. So the initiatives from the NJEDA, everybody should look into that in addition to the PPPs.
Good news.
Okay, thank you. The next question we have is, suppose a laid off employee refuses reemployment. Does that count against the employer for forgivability? And what I've heard from our panel so far is it's not the specific employee, it's the amount that you're paying towards your payroll that is what you have to spend and what you're receiving. So I'll turn that over to Tom, but I'm thinking that's the test, correct?
I lost.
Are you there, Tom?
I lost that. My screen froze. I apologize.
Oh.
Can you repeat that?
Someone's asking whether a laid off employee.
But you froze. I didn't hear the question.
Okay. Suppose a laid off employee refuses reemployment. Does that count against the employer for forgivability?
So they quit.
They quit. They don't want to come. Oh no, you laid them off because you could the payroll going, but now you're getting the PPL. You want to bring them back, and they say no.
I don't know that that was specifically addressed in the language. My gut would tell me that a full-time equivalent is a full-time equivalent. I don't know. Frank, what do you think?
I believe an FTE is an FTE.
Yeah.
It's not the specific FTE. It's the slot, I guess.
It's not addressed. However, both the Act and the regulations speak to full-time equivalents.
Right.
If an employee is on quarantine, does the employee need a doctor's note under Family First? And how many times can an employee get paid the 80 hours? That might be a question for Jim.
I'm sorry, Joe. Can you repeat that one again?
Sure. If an employee is on quarantine, does the employee need a doctor's note under the Families First Act? And how many times can the employee get paid the 80 hours?
Yeah. So there is a requirement that the employee, employers can require employees to provide information that they are subject to a quarantine order, and employers can request that documentation before paying out on that. And you're only eligible once for the 2 weeks of paid sick leave.
Thank you. We got another one. My bank is telling me that for employees making over 100,000, they are only calculating the 100,000 and not the additional amount. So the employee is being included. So I guess the question, and maybe I'm saying it wrong, is if you have an employee that's making over 100,000, the bank wants to cap it at 100,000 and not include healthcare or any other associated payroll costs on top of the 100.
That's not what the bill reads. And unfortunately, we've had those situations. I don't know what to say, but that's not what the bill is intended to do.
And I'm not looking, and maybe we can't do it, but are there any banks that we know of, not anything specific, that are handling these applications better than others?
I don't know that I want to.
Okay, it just as people are having issues, I'm getting some questions regarding banks telling them certain things. I guess the only advice we have is if that bank has an issue, if they have a relation somewhere else, or talk to their accountant. But somehow,
frankly, I'd be curious to know who the bank is. Maybe maybe if you want to reach out to me, send me an email or something like that. I'll see if I have a contact at the bank. Maybe we can help you out.
So to whoever asked that question, that's probably the best way of dealing with it. If they want to send that information to Tom, he's willing to try to help and work that out for you. And a reminder on the I guess the navigation bar that you have on your screen, there are 3 handouts. The one that says virtual courtroom is actually the CLE seminar application for the 2 free CLEs that the Bergen County Bar is offering. There is at the top, the first handout is BCBA speakers, which has all the contact information for everybody that appeared in the seminar. So if you have a question like that regarding your bank or how to deal with your bank, Tom has graciously offered that person who asked that question to offer whatever assistance he can with respect to that application, or answer the question, I guess, privately offline. So thank you very much, Tom, for that.
Sure.
And I think that may be it for questions. Bill, are you back on, or can you want to video yourself back on for to close this out?
Yes, I will.
Okay, well, we're waiting. Bill's coming on. I want to thank all our speakers. I want to thank the Bergen County Bar Association again for helping to put together this presentation. I think everyone did a very fine job of a very difficult and quickly changing subject. Everyone is available, as I said, on the speaker list that we have. If there are questions, please reach out. The seminar probably, I think, is going to be recorded and may be available again to look at. You can also download the seminar materials, the slideshow that was done, which can help refresh or answer some questions that you may have. So thank you again, everyone. And Bill, to you.
Yes, thank you, everyone. And thanks to Frank O'Mara, who was intimately involved in putting this together. Joe, thank you for hosting. And Rich, thank you for your insights. And thanks to all the panelists, especially Frank and Tom, who carried the heavy load here. So
Appreciate
great job.
it. Thanks, Bill.
Thank you.
Sure.
Stay safe,
All right,
stay home.
Back to you, Joe.
Everyone stay home, stay healthy, and stay safe.
Thank you.
You too.
Stay safe.
You too.
Bye-bye.
Take care.
Bye-bye, everyone.
Thank you.
Thanks a lot.